Breaking now. The appellate court has denied Melania Trump's final appeal. Reported sources say the ruling leaves the civil fraud judgment intact and, crucially, removes the last major legal lever her team had to delay or limit federal prosecutors' options. That denial, according to multiple people briefed on the matter, has triggered immediate, high-stakes negotiations, cooperation talks that could reshape the entire investigation. To be clear, the civil finding that began this cascade remains on the record. As one passage in the extracted timeline put it, the court finds by clear and convincing evidence that defendant knowingly submitted materially false sales data to induce plaintiff's $12 million payment. That language, the word knowingly, is the hinge on which everything now turns. Today's appeal denial converts a contested civil dispute into a fixed judgment that prosecutors can use as leverage in criminal negotiations. Over the next 24 minutes, I'll walk you through how this denial changes the legal landscape, what cooperation could look like in practice, the immediate pressure points and deadlines, and the 3 plausible near-term outcomes prosecutors and defense teams are now racing toward. I'll also explain why this is not just about one licensing deal anymore.
With the opening recap and why this matters, start with the timeline. The civil fraud finding came first. The judge's referral to the Department of Justice followed. The DOJ opened a criminal investigation and issued preservation orders. Now the appellate court has denied the final appeal. Each step tightened the legal noose. The civil judgment, reported in court filings and summarized in the original timeline, included a $12 million disgorgement and punitive damages that could push the total judgment into the tens of millions. With the appeal denied, that judgment is effectively locked. Why does that matter to prosecutors? Because a locked civil judgment removes bargaining chips for the defense. It converts potential future civil remedies into present enforceable leverage for the government. Prosecutors can point to a final court finding of knowing fraud when they ask a grand jury to indict or when they negotiate plea terms. Put another way, before today, defense counsel could credibly argue the civil case was unsettled and that any criminal inquiry should wait. After today, that argument collapses. The playing field has shifted from delay and defense to negotiation and damage control.
Immediate reaction and reported developments. Sources familiar with the matter told reporters this morning that DOJ prosecutors moved quickly after receiving notice of the appellate decision. Within hours, teams were convening to reassess grand jury strategy and to open lines of communication with defense counsel. We're seeing movement on both sides, one source said. Another person familiar with the discussions described the mood inside the prosecutor's office as focused and pragmatic, adding that the goal is to determine whether cooperation would yield broader targets or simply resolve the case against the individual defendant. The appellate denial also triggered immediate operational consequences. Banks and financial institutions that had been holding documents under civil discovery now face the prospect of federal subpoenas and grand jury demands. That accelerates the timeline for evidence collection and witness interviews. What cooperation could mean here? When reporters say cooperation, they mean a range of possible arrangements. At the low end, cooperation can be limited. The defendant provides documents, answers questions, and accepts a plea to a lesser charge. At the high end, cooperation can include sworn testimony against other targets, detailed admissions about organizational conduct, and assistance in identifying additional evidence or witnesses. In this case, sources say prosecutors are particularly interested in whether testimony could implicate executives within the licensing operation or reveal a broader pattern of conduct across multiple deals. But cooperation has limits. Spousal privilege and other legal protections constrain what a defendant can offer about a spouse. Multiple sources emphasized that Melania's ability to provide information about Donald Trump directly is legally constrained. She can't waive spousal privilege for him, one legal analyst said. That's a hard line. Instead, the likely bargaining chips are internal communications, testimony about licensing negotiations, and identification of other executives who handled projections, spreadsheets, and contract negotiations. Final civil judgment does 2 things for prosecutors. First, it establishes a judicial finding of wrongdoing that prosecutors can cite in grand jury presentations and plea negotiations.
Second, it creates immediate civil remedies, disgorgement, punitive damages, and enforcement mechanisms that can be used to pressure a defendant to cooperate to avoid both criminal penalties and civil enforcement actions. In practical terms, a $45 to $52 million judgment, if enforced, can strip away financial resources that a defendant might otherwise use to mount a prolonged criminal defense. That financial pressure often makes cooperation more attractive. Defense teams sometimes use the threat of civil enforcement as leverage to resist cooperation. Prosecutors use the reality of a locked judgment to push for cooperation. Today, the balance tilts toward prosecutors. The following dates to watch, the deadlines that will shape the next 2 weeks. Within days, banks and offshore institutions must comply with preservation orders and produce records to federal investigators. Within 1 week, grand jury proceedings are scheduled to begin. Prosecutors will present evidence and witness testimony. Within 2 weeks, prosecutors may seek an indictment, or alternatively, continue the grand jury process while negotiating cooperation. Each of those deadlines tightens the timeline for decision-making. Bank records can reveal money flows and offshore transfers that either broaden the investigation or narrow it to a single deal. Witness testimony, especially from former executives and accountants, can corroborate the judge's finding of knowing falsity or introduce new targets. The next 7 to 14 days are therefore decisive. They will show whether prosecutors have enough to indict quickly, whether they prefer to negotiate a cooperation deal, or whether they need more time to expand the probe.
Who the key players are and what they want. On the prosecution side, senior DOJ financial fraud prosecutors, FBI investigators, and state prosecutors in New York are coordinating. The judge who issued the original civil finding remains a central figure because her opinion included detailed factual findings and a prosecutorial roadmap. That roadmap, sources say, made it easier for DOJ to move quickly. On the defense side, high-powered criminal defense attorneys, civil appellate counsel, and business lawyers are evaluating options, from immediate cooperation to fighting any criminal charges in court. Outside players matter too. Banks, offshore institutions, and former executives who may be called as witnesses. Their documents and testimony will shape whether this remains a case focused on one licensing deal or expands into a pattern across multiple deals. The evidence picture and what prosecutors already have. Based on the civil opinion and reporting, prosecutors already have several key pieces. The judge's 47-page finding, 89 pages of exhibits, sealed whistleblower statements, and a paper trail of alleged falsified spreadsheets. Those materials provide a foundation for a criminal case. The civil opinion's repeated use of the word knowingly is particularly significant. It supplies the mens rea, the intent element that criminal statutes require. But prosecutors still need corroboration. Bank records showing the flow of funds, witness testimony confirming who created and approved the false data, and documentary evidence tying false statements to the intent to obtain money. That's where the bank productions and grand jury testimony come in. Plausible cooperation scenarios. Scenario A, limited cooperation. The defendant provides documents and limited testimony, accepts a plea to a lesser charge, and receives a reduced sentence or probation. This resolves the case quickly, but yields little new information about other potential targets. Scenario B, full cooperation. The defendant agrees to testify against other executives, provides detailed admissions, and helps prosecutors build a broader case. In return, prosecutors offer a significant reduction in charges or sentencing exposure. This is the outcome prosecutors prefer if they want to expand the probe. Scenario C, no cooperation, immediate indictment. Prosecutors proceed to indict based on the existing record and grand jury evidence. That leads to a criminal trial or plea negotiations under the pressure of an indictment. Which scenario unfolds depends on what the bank documents show, how persuasive the whistleblowers are in grand jury testimony, and whether the defendant's legal team believes cooperation is the only realistic path to avoid prison. The limits of cooperation and legal constraints. Cooperation is not a magic wand. Legal protections, spousal privilege, Fifth Amendment rights, and attorney-client privilege limit what a defendant can offer. Prosecutors cannot compel testimony about privileged communications, and defendants can refuse to answer questions that would incriminate them without a plea deal or immunity. Moreover, cooperation requires credibility. If a defendant's admissions are inconsistent or self-serving, prosecutors may be reluctant to offer substantial concessions. That's why prosecutors often seek corroborating evidence, bank records, emails, and witness statements before finalizing any cooperation agreement. How this could expand beyond one deal. The civil opinion and the preservation orders suggest investigators are looking at multiple licensing deals, not just the Lux Brands transaction. If bank records show similar patterns across other deals, inflated projections, upfront payments, and falsified documentation, prosecutors could pursue a broader, enterprise-level case. That raises the possibility of RICO-style theories, or multiple counts of bank and wire fraud across jurisdictions. If cooperation yields testimony that connects other executives or organizational practices to the alleged scheme, the investigation could widen quickly. That's why prosecutors value cooperation. It can unlock evidence that would otherwise take months to assemble. Political and reputational stakes. This is not just a legal story, it's a political and reputational one. A cooperation deal involving a high-profile figure would be explosive politically and could have ripple effects across related investigations. Prosecutors are aware of the optics and the potential for political backlash, which is one reason they move cautiously but decisively. Defense teams, meanwhile, must weigh the reputational cost of cooperation against the legal cost of indictment and potential prison time. Sources say both sides are acutely aware of the stakes. One source told reporters, "This isn't just about one person's legal exposure. It's about whether a pattern of conduct gets exposed and who else might be implicated."
3 indicators to watch in the next week. Indicator 1. The scope of bank document productions. If records show transactions across multiple deals and offshore transfers, that points to a broader investigation. Indicator 2. Grand jury witness testimony. If whistleblowers provide detailed, corroborated accounts that match documentary evidence, prosecutors will have the leverage to seek indictments or strong cooperation deals. Indicator 3. Public signals from prosecutors. Speed and decisiveness, rapid subpoenas, quick grand jury presentations suggest prosecutors are ready to move to indictment. Slower, more negotiated steps suggest they are prioritizing cooperation deals. Likely negotiation dynamics. Negotiations typically follow a pattern. Prosecutors present the evidence and the potential charges. Defense counsel assesses exposure and bargaining chips. Both sides explore whether cooperation can yield broader targets or simply resolve the individual case. In this matter, the locked civil judgment is a major bargaining chip for prosecutors. Defense counsel may counter with offers to provide limited cooperation in exchange for non-prosecution agreements for certain individuals or for reduced sentencing recommendations. But prosecutors will demand verifiable, actionable cooperation, not vague promises. That means documents, sworn testimony, and credible admissions. Historical parallels and lessons. There are precedents where cooperation by a high-profile defendant led to broader investigations and additional indictments. In those cases, cooperation often produced internal documents and witness testimony that prosecutors could not have obtained otherwise. Conversely, there are cases where limited cooperation only produced narrow resolutions and left larger organizational issues unaddressed. The lesson for both sides is clear. Cooperation can be transformative, but only if it yields verifiable, corroborated evidence. What an indictment would look like and its consequences. If prosecutors move to indict, charges would likely include bank fraud, wire fraud, and false statements, the same statutes referenced in the civil opinion. An indictment would trigger criminal proceedings, potential pretrial detention or bond conditions, and a public trial unless a plea is negotiated. Criminal convictions carry prison exposure that far exceeds civil penalties. Bank fraud, for example, can carry decades in prison depending on the counts and the scale of the alleged scheme. An indictment would also complicate civil enforcement and could prompt additional civil suits or enforcement actions by state authorities.
State parallel investigations and coordination. At 1428, the New York Attorney General's office is reportedly conducting a parallel review. State prosecutors can pursue charges under state fraud statutes, even if federal prosecutors make a deal. Coordination between federal and state authorities is common, but each office has its own priorities and tools. That means a federal cooperation deal does not necessarily immunize a defendant from state action, unless the deal explicitly addresses state concerns, which is rare. Defense teams must therefore negotiate with both federal and state consequences in mind. The role of whistleblowers and former executives. Whistleblowers who provided sealed testimony in the civil case are now potential grand jury witnesses. Their accounts, if corroborated by documents and bank records, can be decisive. Prosecutors often rely on insiders to explain how false data was created, who approved it, and why it was presented to counterparties. Former executives and accountants who can produce original spreadsheets or communications are particularly valuable. If those witnesses cooperate with prosecutors, the case could expand beyond a single defendant. Defense strategies and possible responses. Defense counsel has several options: seek emergency relief from higher appellate courts, negotiate for limited cooperation, or prepare for criminal defense. With the appeal denied, emergency appellate relief is unlikely to change the immediate landscape. That leaves negotiation and defense preparation. Some defense teams choose to fight aggressively in court. Others prioritize minimizing exposure through cooperation. The choice depends on the client's risk tolerance, the strength of the evidence, and the potential collateral consequences. Media, public perception, and political fallout. High-profile cases generate intense media scrutiny. Public perception can influence political actors, and indirectly, prosecutorial calculations. Prosecutors are mindful of the optics, but must base decisions on evidence and law. For the defendant, public perception can affect reputation, business relationships, and the willingness of potential cooperating witnesses to come forward. 3 near-term scenarios revisited with indicators. Scenario 1, cooperation announced. Indicators include rapid, private meetings between defense counsel and prosecutors, limited public statements indicating talks, and a sudden slowdown in grand jury activity as negotiations proceed. Scenario 2, indictment. Indicators include rapid grand jury presentations, subpoenas for bank records, and public filings signaling imminent charges. Scenario 3, extended investigation. Indicators include staggered document productions, additional witness interviews over weeks, and no immediate public resolution. Each scenario has different implications for timing, publicity, and legal exposure.
What to watch in the next 7 to 14 days. Watch for 3 concrete developments: the scope of bank document productions, the identity and testimony of grand jury witnesses, and any public filings or statements from prosecutors indicating an indictment or cooperation agreement. Also watch for any filings in civil court that could affect enforcement of the judgment, and for statements from state prosecutors about parallel actions. Those signals will tell us whether this is headed toward a quick resolution or a prolonged, expanding investigation. Practical implications for related parties. For banks and offshore institutions, expect subpoenas and compliance obligations. For former executives, expect potential witness requests and, in some cases, target status. For the broader organization, expect reputational and financial consequences that could affect licensing deals and partnerships. For the public and investors, the legal uncertainty can affect valuations, partnerships, and future licensing opportunities. Closing analysis and final takeaways. The appellate denial is the inflection point. It converts a contested civil matter into a fixed judgment that prosecutors can use as leverage. Cooperation talks are reportedly imminent because the defense's options have narrowed and prosecutors now have a stronger hand. But cooperation is not guaranteed. Legal constraints, credibility concerns, and the scope of evidence will determine whether prosecutors seek a cooperation deal or move straight to indictment.
The next 7 to 14 days will be decisive. Bank records and grand jury testimony will either broaden the probe or confirm that the Lux Brands matter was isolated. Those outcomes will determine whether this becomes a single defendant prosecution or the opening chapter of a wider investigation. Final thought. This is a legal story that moves fast when evidence and leverage align. Today's appeal denial is not the end. It's the moment when options narrow and decisions accelerate. Expect rapid developments and watch the 3 pressure points we outlined: documents, witnesses, and grand jury activity. If confirmed, one source said, this denial makes cooperation the rational choice for anyone who wants to avoid the worst criminal exposure. Another added, prosecutors now have a roadmap. It's a matter of whether they want to use it to build a broader case or to secure a quick resolution. We'll be tracking every development closely. In the coming days, we'll report on bank productions, grand jury activity, and any formal cooperation agreement or indictment. Subscribe for the full breakdown as documents and testimony become public. That's the current state. Appeal denied, civil judgment locked, cooperation reportedly imminent, and a fast-moving federal investigation that could expand or resolve quickly, depending on what the evidence shows. Stay tuned. The next week will tell us whether this is a path to indictment, a cooperation deal that exposes more, or an extended investigation that unfolds over months. Either way, today's denial changed the game. End of briefing.